Thank you everyone, and welcome to this GAR Lexology webinar exploring the topic of what arbitrators and counsel really want from virtual alternative dispute resolution. My name is Kylie Peterson and I'll be your host today. I'm a legal practitioner with 20 years of experience in the application of technology to contentious legal process. My focus is in the consulting space, providing advisory support to legal teams across the litigation lifecycle. And my team and I work with market-leading technology, including software from Relativity, Nuix, and Delium. I hold director-level roles with eLaw and Delium. Today's topic is enlightening because rather than it being a solution-driven pitch about the way you should manage virtual ADR, it considers and analyses what participants in the sector have identified as their perceptions of virtual procedure. These responses are the product of a research project undertaken late last year as a collaborative effort between Delium, a technology provider in the e-litigation sector and particularly in the e-hearing space, and the Chartered Institute of Arbitrators Australia. Members of the Institute and a wide body of counsel and legal practitioners answered 35 questions designed to probe their attitudes to virtual and hybrid proceedings, with a view to garnering a better understanding of the attitudes and needs of those at the coalface. Today, we're going to discuss and analyse key findings with the assistance of an expert panel. I also welcome your input. Please use the online question tool, and we hope to have time to address those at the conclusion. If you have any audio-visual problems, please use the same question tool and the organisers will do their best to resolve them. Finally, please note the recording of this session will be posted online and we will send a link to all webinar attendees. I'm delighted to introduce today's expert panellists. Professor John Sharkey, AM, is a professorial fellow at the University of Melbourne and a commercial arbitrator. Professor Sharkey has practiced construction law for over 40 years. He is a co-author of Building and Construction Contracts in Australia and Commercial Arbitration. Professor Sharkey was a founding board member of the Society of Construction Law. He is the state editor for Victoria and Tasmania of the journal Building and Construction Law and is the former chair of the Law Council of Australia's Construction Law Committee. Professor Sharkey was appointed an honorary professorial fellow at the University of Melbourne in 2015 and in 2020 was elected as a fellow of the Australian Academy of Law. He's head of the research arm of the Construction Law program at the Law School of the University of Melbourne and practices as a commercial arbitrator both domestically and internationally. Andrew Di Pasquale is a barrister with List G Barristers in Melbourne and a fellow and national counsellor of the Chartered Institute of Arbitrators Australia. Andrew practices in commercial law and international commercial arbitration with experience in international arbitrations both as counsel and arbitrator. Prior to joining the bar, Andrew was a solicitor with varied commercial experiences in private practice and in-house, including roles at DLA Piper in Dubai, King & Wood Mallesons as it then was, and Clayton Utz. Andrew was also the legal assistant to international arbitrator Neil Kaplan. And finally, welcome to Jamie Reiki, who is a solicitor, a senior associate with Brodie's LLP in Edinburgh, Scotland. Brodie's is the leading UK firm and has the largest dispute resolution practice of any law firm headquartered in Scotland. A solicitor advocate with the right of audience in Scotland's highest civil courts and the UK Supreme Court, Jamie acts as counsel in a wide variety of matters, including debt recovery, insolvency, professional negligence, and contentious trust and executory matters. As well as litigation, Jamie guides and represents clients through different forms of ADR. He has acted in domestic and international arbitrations, appeals of arbitral awards to the Scottish courts, and the enforcement of foreign arbitration awards in Scotland. Gentlemen, welcome and thank you for your time today. So turning to the survey, prior to initiating the research project, it was understood by both Delium and the Institute from their own involvement and also anecdotally that the uptake of technology to support virtual and hybrid ADR processes had been increasing steadily prior to the first impacts of COVID-19 in March 2020, and that after a period of brief inactivity, there was a significant increase in that uptake. Survey respondents agreed that virtual ADR hearings and mediations will continue, irrespective of what happens with future pandemic response. Notwithstanding that there may not be a requirement to participate virtually on an ongoing basis, most respondents see that the model will continue, even if there is some reversion to conventional hearings. So, Professor John Sharkey, as an arbitrator, does it surprise you?
Well, thank you, Kylie, and I extend my thanks to Delium, to the Chartered Institute, and to GAR for the invitation to participate in this webinar. Am I surprised to hear that people consider virtual hearings are here to stay? Well, no, although I suspect that some of the respondents may say it will all depend upon the particular circumstances of the case. If you take, for example, a case that turns on the proper interpretation of the contract, it may be a case that will not justify being loaded with the cost of an electronic or virtual hearing. Although even there, you're going to see the application of IT in the process in some form, depends on your definition of IT, but at the very least, it's going to be limited to email communications between the parties and the tribunal. But if I take the case of a large construction contract where the history of the project has to be pored over and examined in a granular manner from commencement to completion on the floor of the hearing room, then I think the case for an in-person hearing becomes, in my view, harder to make out. And I know we'll come to questions of costs and travel, but I think it's one of those instances where once people have had an experience of an alternative way of doing things, there comes a degree to which there is no turning back to the old ways. And there's no doubt in my mind that the pandemic has hastened that process. Which brings me to my, sorry, Kylie. I was just one other point I'll make. Even if there is a requirement for, in a particular case, for hearings to be conducted in person, perhaps because of some underlying agreement between the parties or some institutional rules, all of that may have to submit to the realities that we're facing. And perhaps the tide is turning more and more towards virtual hearings as the default option. Just last week here in the Supreme Court of Victoria, the state in which Andrew and I reside, the court issued a notice to the profession saying, with the single exception of criminal jury trials, the default position is now going to be for virtual hearings. So if you're seeking an in-person hearing in the Supreme Court, you'll have to make an application. If you're granted an order, there will be orders for social distancing. The court's already acknowledged that's going to limit the availability of courtrooms. Attendees will have to be prepared to undertake rapid antigen tests and so on. Now, we're going to see a very different approach in arbitrations. Well, I find it difficult to see how we will. And even if a decision is made that a final hearing is going to be conducted in person, isn't it going to have to yield to the witness who says, well, for personal reasons or health reasons or family reasons, I'm only going to attend virtually. And here I'm speaking about, of course, the final hearing. I think most of the parties and their representatives now accept that most preliminary hearings and case management conferences are going to be conducted virtually. So in answer to your question, I would say no. And no surprises for me in hearing respondents considered hearings and mediations will continue in a virtual format, even though there may be no express requirement for them to adopt that format.
Thank you. And Andrew, what's your view as counsel?
The acceleration was really already happening before COVID. I mean, COVID was a catalyst for people to kind of get their systems in order so that they could move into this more virtual hearing world. But I mean, as John's identified, the idea that hearings other than the final hearing, even prior to the pandemic, the notion of going to Singapore for some kind of procedural hearing, which was going to last half a day, was already on the way out, and there was already a big movement towards doing that kind of thing online. I think there is an inevitability, and I think that the inevitability is tied to the increasing complexity of disputes to a large degree. John mentioned construction disputes, which are notoriously document heavy, and if you were trying to do that the old way, where it was all on paper, that becomes unwieldy very quickly, particularly because that industry itself has a large electronic document management systems in place, and therefore the amount of paper, or sorry, the amount of documentation that's being generated in modern disputes is such that it is inevitable that you're going to need technology support to deal with those if those projects become litigious. And it's not unique to construction. Finance is another area where that is the case. So I do agree with the survey respondents that there is an inevitable march towards more IT support in the ADR sector, and there is I don't think that if the pandemic were to end tomorrow, it would go back to the level of in-person hearings that existed prior to the pandemic.
Okay, great. So if we then move to the greatest challenge that survey respondents identified facing virtual ADR, it was a very fundamental one, and that was that they believe that they don't know how best to conduct a virtual hearing. So I'm asking you for your response, I guess, because I think as a representative of the Institute, as well as somebody who's involved at the coalface, the Institute strikes me as a body that might be ideally suited to provide education about best practices to arbitrators and counsel appearing in ADR process. So does it surprise you that respondents volunteered that they have a lack of understanding about best practices? And can you see that there might be a role for the Institute in providing, or at least garnering together, the kind of expertise and know-how that would be valuable to pass on to practitioners?
Certainly. I mean, one of the core reasons for the Chartered Institute existing is education about arbitration, and this is now an aspect of arbitration. So I completely agree with you that the Chartered Institute as an organisation, it's something that the Chartered Institute can and has been and will continue to be involved in. As for the respondents saying that they don't know how best to operate a virtual hearing, I think that without having seen the very specific breakdowns in the respondents' backgrounds, essentially, when answering that question, I think just anecdotally you'll find there'll be a very big difference from the large international firms down through to the mid-size, down through to the more boutique operations. And the large international firms they've spent a lot of the pandemic refining their systems and looking at how to best operate their litigation practices. So the amount of support there is probably going to be very different to the amount of support that's going to be required in smaller practices. I do think it's important to note that there are a lot of protocols and practice notes and guidance notes that do already exist around virtual hearings, and that it is difficult to be more prescriptive than those practice notes and guidance notes are, because then you're delving into the technology level. Now, for instance, protocols like the SOL protocol, and there's just trying to recall the exact name, the protocol for online case management international arbitration, which was a joint effort of various large firms, do get a lot more technical. I think the difficulty with education in this area is going to be that it really is a situation where it's going to need various people to educate how to best conduct a virtual hearing, because it's going to need the technology providers to ensure that there's familiarity with their products. And then it's going to require institutions such as the Chartered Institute to put together the checklists to make sure that all the different issues have at least been considered by the parties that are going to be using these platforms.
Yes, and those protocols that you referred to, the survey did actually probe into awareness of some of those specific protocols, and there was a low level of awareness amongst Australian practitioners. So as you say, there are some resources out there that perhaps people just aren't aware of. Jamie, on the basis of your experience internationally in the UK and specifically Scotland, what's your view about this level of awareness about best practices, and how is knowledge being shared where you're located?
The survey findings weren't a particular surprise to me based on my experience in my own jurisdiction, and certainly had the question been asked 2 years ago, I would have had no surprise whatsoever that there was a large response which demonstrated a lack of understanding. I would like to think that that understanding has increased over the last 2 years, and a number of bodies in Scotland have attempted to give guidance and to educate on best practice. And in particular, I'm a member of the committee of an organisation called the Society of Solicitor Advocates, which is a representative organisation for solicitors who have higher rights of audience in the Supreme Courts in Scotland. And we have, over the last year, set up a monthly series of training focusing on the adequacy aspects of remote hearings. But I agree with Andrew that it's going to be something of a team effort, because there are various aspects to conducting virtual hearings and doing that well. The advocacy aspect is one part, but there's considerations for instructing agents, there's considerations for how to use the technology well, and it does involve a fair amount of collaboration to do a hearing well, and it will involve a fair amount of collaboration in order to train people as to best practice.
And on that technology side, the other identified challenge that was one of the two top challenges was that beyond general awareness, there was also a lack of understanding about the suitable technology that might be available. So if we dig deeper into the survey responses, we see that there's still a concern about familiarity with hearing platforms such as Zoom or Teams, which are often a fundamental part of any virtual hearing solution, as well as feedback about the perceived inadequacy of those platforms for comprehensive evidence management. So we'll explore some of those deficiencies next. But Professor John Sharkey, were you surprised to learn that respondents still don't feel adequately familiar with Zoom and Teams? Do you think this is perhaps because they're not just being used for their basic collaborative capabilities, but that there's more to a virtual ADR process being expected of them than there should be? For example, use of private rooms and evidence management techniques. Or do you think there's another reason?
Well, when you speak of the basic capabilities, and taking Jamie's 2-year period, I think I hadn't heard of Zoom or Teams 2 years ago, and I've found in that time that I've been pretty much on a learning curve, and I suspect I'm not alone. I don't know that more is being expected of parties, but perhaps the IT providers could need to be a bit more involved in educating the profession about what those capabilities are. And but my message to them would be to try and keep it simple. I've had instances of providers spending a lot of time explaining to me the various exotic options and alternatives that these systems can offer, when what I really think I need is a continuing education on the basics.
Interesting. So if we then turn to the concerns raised in relation to the hearings themselves, once we're in the context of a hearing, survey results highlighted concerns with two key functions, being evidence presentation and witness management and examination. And there's probably no real surprise there that those two issues have been raised. So if we turn first to evidence presentation, I wonder if this concern is connected with the high reliance on those generic collaborative platforms that we've talked about, such as Zoom or Teams. Obviously, they have screen sharing capabilities, but they're otherwise quite a blunt tool with no extended functionality. Does it surprise you, Jamie Reeking, that evidence presentation was identified as the #1 challenge? What has been your experience?
Again, that's not a surprising outcome, certainly from my experience. Evidence presentation is something that has exercised me and many of my colleagues whilst we've got used to the acceleration of virtual hearings. And I think part of it may be down to a reliance at times on these generic platforms, and certainly even in the court system in Scotland, it's a generic platform with limited functionality that we use, and it requires quite a lot of preparation and again teamwork between the legal teams, between counsel and the instructing agents as to what is going to be required for a hearing to determine whether those basic functionalities will be sufficient. And I conducted last year a 2-week trial in our National Civil Court using simply a share screen function in a relatively document-heavy process, whereby we had one joint bundle of the documents that were to be used and simply shared that PDF on screen. But again, that required a fair amount of preparation in advance as to who was going to operate the screen, how that person would be told where to move to within that document without breaking the flow of the presentation of the evidence and the examination of the witnesses. Conversely, I've also had experience of a much more involved platform which had its uses in particular in the case that we use it in, where there was much more scope to manipulate the documents and to zoom in and to find documents quickly. And in that case, that I was required because of some of the technical nature of some of the documents, and it really just brings me back to the idea of it requires preparation, as do most aspects of a virtual hearing. Requires teamwork and preparation in advance to ensure that you're using the platform that's going to help you present the case the best.
And I expect that in circumstances such as the former example that you cited, where everybody's just accessing basically a giant PDF, I imagine that participants still turn up then with lots of pieces of paper because their solution really is inadequate in terms of assisting with your document review your evidence review whilst you're in the hearing.
Yeah, you're either using paper or you have various versions of the same document. Where there's one document that's being shared on screen with the court or tribunal and witnesses and the other participants, that version of course has to be clean. You can't have your own notes on it, you can't have highlighting, and there are solutions out there that allow you to have your own private copy, essentially your own folder with your own markup, but to share that with the tribunal and with the witnesses without your own markup and your own comments that you may not wish anyone to see.
Okay. Yeah, and that actually brings us very neatly to the next slide, which I'm going to ask Andrew to comment on, which is when we dug a little deeper about evidence presentation and the concerns that people had. The slide or the survey respondents told us that what they're missing in a virtual context often is the kind of capability, interactivity that they had in an in-person hearing. So this ability to interact with evidence in the way that previously they were able to in an in-person hearing, I think has been lost in many virtual solutions, such as the kind of strategy that Jamie was just referring to a moment ago. So the survey results told us that counsel or their teams would like to be able to interact with the evidence by presenting with it, working with it, annotating, making notes. And certainly if we look at the next results, which we've summarised here, I think it's really interesting to note, and perhaps this is an indication of the increasing comfort that practitioners now have working with technology, or maybe just an evolution of best practices in the hearing space, that only 4% of respondents took the view that a third party needs to be engaged to present evidence. So Andrew, I know we've covered quite a lot there, but what's your view? Can you see why respondents feel that perhaps they've lost something in a move to a virtual space that doesn't really try to accommodate some of those more traditional ways that counsel and legal teams want to work with evidence in the hearing?
I'm not surprised. I mean, Jamie mentioned people having their own copies of the bundle in response to the last answer. I mean, the reality of trial preparation or hearing preparation is that you don't get these documents as a counsel or a solicitor 6 weeks before the hearing. You've probably had them for a much longer time, and you've got your own versions of the documents which you've been working on for a long time, and then the hearing documents are clean versions of those documents for the purposes of evidence preparation. Now, merging those two things, your own documents and the hearing documents, so as to facilitate an easier transition between the two, is a very difficult technical problem to address, because you really need to have platforms interoperating all the way from the start of a dispute all the way up until the hearing. So no, it doesn't surprise me that people think that they've lost something if they're working entirely electronically, when what they're comparing that to is to have a well-marked and well-dog-eared paper bundle that has been with them for a long time and pretty much represents their work product on the case. As to the presentation of the evidence and the response that there's a belief that a third party should not be used, I'm surprised at the numbers, but I'm not surprised at the sentiment that that people do want to control their own evidence. And I think again that comes down to familiarity, because again, the reality of a hearing is, and Jamie mentioned this, that the amount of cooperation that's required to have electronic hearing bundles being operated by someone else who doesn't necessarily have the familiarity with the material means it's got to be very specific. You're talking document IDs, this page number, this paragraph, whereas if the parties, counsel or solicitors are controlling the evidence themselves, well, to them it's that clause in the contract of the 15th of May, and that just takes a bit of a mental load off during a hearing, I think. So I think that legal teams should be empowered by the platforms to take control of their own evidence preparation for that reason.
And just means that the platforms need to be simple enough to use so that parties can feel well prepared to do that and comfortable in doing that while they're in the hearing process. Yeah.
Absolutely, it's got to be. There's still got to be rehearsal and preparation. It's just it's the rehearsal and preparation within the legal teams for the parties to make sure that that is still not subject to delays, I guess.
Yes. So Professor Sharkey, staying with evidence, 100% of respondents believe it is useful that the arbitrator have ongoing access to the integrated record, that being the witness testimony linked to evidence, for the purpose of writing the arbitral award after hearings. I know you did not participate in the survey. Are you an outlier, or do you agree that this is useful? And perhaps you could indicate whether this is a capability that you're routinely provided with in virtual or hybrid proceedings.
Well, it would be an arbitrator more courageous than I am to say they disagreed with every respondent that having continuing access to the electronic record was useful in the award writing exercise. Again, however, it might all depend upon the particular case, but in the case of a large document arbitration, the great value to me of having the record of the hearing in electronic form lies in the searching capabilities that it offers. Before the IT age descended upon us, my practice was to identify each issue on a separate page in handwritten form, and I'd then supplement the identified issue with handwritten cross-references to particular pages or paragraphs, the witness statements, expert reports, transcript, and so on. And I've got no doubt that in that way I missed many of the available references, but you did the best that you could. With an electronic format, I can type in the search bar not just the name of the issue, but a central or recurring phrase, delay analysis. And with a click, I can be told of every instance where the phrase appears in the transcript or a witness statement or an expert report. Now, that's not just a more reliable and accurate foundation upon which to conduct an award writing exercise. It's far more time efficient and cost efficient compared to my old and not entirely abandoned practice of being surrounded by 4, 5, 10 or more lever arch files, all replete with color-coded post-it notes as I try and work out who said what to whom and when they said it. So perhaps more than merely useful, I find I've become very dependent upon the integrated record, preferably hyperlinked.
Mm-hmm. Great. So if we could now turn to witness management, which was the other key challenge that respondents volunteered, I'd like to look at two key components here, which are witness credibility and integrity of the witness examination process, which unsurprisingly were raised as two key potential disadvantages of virtual ADR. So, Professor Sharkey, again, if we firstly consider the integrity of witness examination, has this been an area of concern for you where evidence is given virtually? And if so, would it provide you with greater comfort? What would provide you with greater comfort? So is it a matter of having protocols in place that you feel comfortable with, or perhaps you'd like to see implementation of the kind of strategies that are common in higher education examination contexts, such as virtual inspection of the room in which the witness sits and the use of mirrors? What's your experience and view?
Well, I don't know that I'd want to impose higher education examination strategies on witnesses in the essentially consensual context of an arbitration, but the question of the integrity of cross-examination seems to be raised now and again as something that might count against virtual hearings when comparison with in-person hearings are made. I can't say I've had any personal experience of anyone complaining that the integrity of the process has been compromised by the hearing format, but there's some elementary precautions a party can take to preserve the integrity of that cross-examination. Arrangements can be recorded in a hearing protocol, for example, for an observer in the room of the witness during cross-examination, and that will eliminate any prospect of an undisclosed third person being present to assist or prompt the witness, or the witness reading from notes or some other record that's not visible to the cross-examiner. It may be necessary for a technician to be present with the remote witness, and if it is, that technician, in my experience, can be seated behind the witness so that they're visible to participants, but not to the witness. There are other ways in which this issue can be satisfactorily managed. I've seen counsel opening their cross-examination where there is no observer asking the witness to identify any persons present and any documents that the witness has with them at the time. You can ask the witness to rotate the camera 360 degrees so that everyone can get a view of the room where the witness is seated. So yes, it's possible to identify the risk that you mentioned, but I think it should be capable of being appropriately managed. And I think most practitioners are going to advise their clients' witnesses that observing relevant protocols or institutional rules or arrangements between the parties is vital, and that the tribunal can be expected to react adversely to their client's interests if it finds there's been a breach of those protocols or arrangements.
Mm-hmm. And what of the credibility assessment? I know a number of international studies have looked into this issue, and in fact, one of our arbitrator registrants today has already noted that perhaps we're not as good necessarily as reading the witness virtually as we would like to think we are. Do you consider this as a challenge that, from your perspective, can be addressed in a particular way? Is it a matter of adjudicators developing a different approach when making this kind of assessment in a virtual context?
Again, I think that we are dealing with change and change in this particular aspect and our treatment of it. This is another constant discussion topic. There are those who will say that the issue of credit, there's no substitute for a witness having to respond to the cross-examiner in the physical presence of the cross-examiner. You're best able, so the argument goes, to assess truthfulness by watching how the witness responds to cross-examination when they are in the same room with you 5 or 10 metres away. I'm not convinced that the virtual alternative is less effective. For a start, the witness is going to be closer to you on a screen than they will ordinarily be in the hearing room. And the case can be made, I think, that you're better able to observe facial features in that way. No doubt the witness is going to be more comfortable in giving evidence in a virtual hearing where they'll often be in their own home or office environment rather than some remote, austere, distant hearing room feeling very alone. But I doubt that you get greater truth from discomfort, and I think that any difference will rarely be a material factor in the assessment of credibility.
Mm-hmm. And Jamie Reiki, what is the standard approach for witness management in the UK? Are you used to working with the protocol for the management of witness evidence? And if so, has there become an accepted professional standard? Or perhaps you have some pointers for witness management that have become apparent to you based on your experience?
I'm not aware of any particular standard approach. The use of protocols is, or certainly in-depth protocols, is something that seems to exercise arbitral tribunals more than the courts. Our courts here have a fairly short guidance note on what's required of witnesses, and essentially they are to be in a room on their own, and a judge will ask them, is there anyone else present with you? Have you switched off your emails? Do you have a way of communicating with the outside world? And provided the correct answers are given to those, then we move on to examination. And that seems to work relatively well. I think that there's a fair amount of distrust, which is perhaps understandable given the acceleration to virtual hearings, and that many people are still finding these, certainly finding evidential virtual hearings to be new things. But I suspect that mistrust will start to taper down over time, and perhaps the use of in-depth and overly technical protocols might might also taper down. With regards to witness management, like anything in a final hearing, preparation for me is the key, and to ensure that there is discussion between the legal team and the witness as to what space is going to be used, what technology and hardware the witness has available, and to ensure, as I think we'll come on to, that the witness is made fully aware of what they can do, what they can't do, and their responsibilities to the tribunal.
Can I just say, Carly, on response to Jamie, one thing just occurred to me as Jamie was speaking. I think when you're speaking to witnesses and you just simply offer them the virtual hearing, you can do it in home or you can do it in an office. You've got to go a little further than that, because sometimes if you say to them, well, we may have an observer from the other side there, we may have a technician as well. Some of them will say, well, I'm not comfortable about doing that in my home and I'll go and deal with it in an office. So there's a task facing the practitioners to talk carefully to the witnesses about what the options are and what they involve.
Yeah, I absolutely agree with that, and that's part of ensuring that the witness is fully aware of what is going to happen on the day. And as John said, that rests on the legal team of who is calling the witness to give evidence, to ensure that that witness is fully aware of what's going to happen, and so that they know their options and know from where they would prefer to give their evidence.
So we might turn now to what the witness is actually shown in a virtual context. So I'm turning to a survey question now, which delivered a very clear position from respondents. So Andrew, I might address this to you, please. 96% of respondents believe that parties and witnesses are potentially disadvantaged if a witness is shown only a portion of or a page of a document when being examined. And I think perhaps this is one of those backward steps we might have taken in moving from conventional to virtual process. So I'm aware that a lot of first generation evidence presentation technologies relied heavily on call outs of the relevant part, which might be visually impressive, but arguably fails to meet best practices for putting evidence to a witness, because it doesn't provide context for the evidence that they're being examined on. So do you agree that parties should insist that witnesses are provided with comprehensive access to the item of evidence in the same way that they would probably demand access to a whole document if the proceedings were in paper format?
Absolutely. I think the surprising part about this response is the 4% who think otherwise. And of course, your answer to this would change if you were the cross-examiner or you weren't the cross-examiner. But the simple fact is that the evidence is still the evidence, and if the witness is being asked questions about a document, the witness should be able to see the entire document. I mean, the question here, as it's phrased, is a party or a witness potentially disadvantaged if the witness is only shown a portion of the evidence? So I take that to mean that they don't have access to the rest of it during the questioning, because they're not disadvantaged if the platform is taking their attention to a certain piece of the evidence. In much the same way, if they had a paper document in front of them, you might ask them to go to page 4 and paragraph 3. But if you do ask them to go to page 4 and paragraph 3, they've got the entire thing in front of them, and there needs to be an equivalence to that if you're dealing with it electronically.
Yeah, so there is clearly a distinction there between just highlighting an element of the document but providing complete access to it, as opposed to just showing them a portion, which I guess the question strongly suggested was not a favourable position.
Yes,
so just yes, finishing out on witness preparation, and I think we've actually already addressed this at least somewhat in our previous question. I just wanted to talk quickly about the logistics of preparing the witness technically and logistically for remote examination. And as I said, I think perhaps this has already been covered in Jamie and John's previous discussion about witness examination. But I really wanted to get a feeling for from the practitioners here who are counsel or from the solicitor legal team. Do you see that the logistical and technical preparation of the witness who's giving evidence remotely is the responsibility of the legal team, or do you expect a service provider to be fulfilling that role for you? Andrew, is there anything that you'd like to say before we hand over to Jamie?
Yeah, I mean, as counsel, we don't have the level of interaction with the witnesses as the solicitors do. But one thing that comes up as far as witness preparation goes is witnesses are ordinarily told to make sure that they understand the questions before they answer questions, and that becomes vitally important, particularly in an online environment, especially if you're working through translators who may also be remote from the witness. The more barriers you put in between people, the more misunderstandings there can be. So I think that as far as witness preparation goes, that's probably the extent that has been changed for counsel, is just really making sure the witnesses are understanding what's being put to them in the hearing, and also speaking up if they're having technical problems, because there's no point just soldiering on. If you've got a very terrible audio link or a very terrible video link, they should be demanding that it be fixed before it proceeds. So that's really my limited perspective on it.
Jamie?
Yeah, in terms of the technical support, part of that may depend on what kind of platform you're using to conduct your hearing. If there is a specialist platform being used, then that third-party provider, I think, does have to be involved in the preparation for the witness, simply because that provider is best placed to talk the witness through how to use it, and the legal team is unlikely to have that level of familiarity. With regard to the rest of the preparation and familiarisation, as I've already said, then for me that comes down to the legal teams, and it's the responsibility, in my view, of the team leading a witness to ensure that the witness has all the information that they need to be able to give their evidence effectively.
Great. So we should turn to the benefits, because so far all we've talked about really are challenges and disadvantages. And lest anyone think that the survey respondents had only concerns about virtual ADR, it's not the case. As we discussed at the outset, there is an overwhelming perception that virtual ADR is here to stay. So we've explored some of the reasons for that view, but we need to consider some of the benefits that have been identified. So as we would expect, the dominant identified benefits had to do with time and geographic flexibility, convenience and travel. I think they're all quite obvious and probably don't need further examination. Cost reduction was identified as a benefit. Jamie, Ricky, in your experience, do you expect that cost reduction is tied to outlays only, such as airfares and accommodation? Or do you think that there's more to it than this? And I guess I should make the point here that naturally the cost of ADR is not going to be static. It will be strongly impacted by service overhead of whatever kind of support or solution is being provided, so that if the virtual solution requires heavy support load, the engagement of multiple service provider representatives, then that's going to add cost in ways that won't be the case if the solution provided is more hands-on for the practitioners and doesn't require that level of support.
Yeah, cost reduction, in my experience, is probably more of a superficial benefit. It's easy to point to the outlays that you've mentioned, that there's no need for flights and accommodation, and to point to that as being a saving. In my experience, virtual hearings will often take longer. There is inevitably an IT issue, even if that is someone's internet drops at some point during the hearing. It can often take a little bit longer to ensure that people are seeing the documents or understanding submissions correctly. And I've mentioned preparation a lot already today. The amount of preparation required for a virtual hearing, in my experience, is certainly much more than one would normally expect for an in-person hearing, and all of that builds in additional cost. So there is the distinct possibility that any savings and outlays are then swallowed back up in the time spent on a case by a legal team, although as virtual hearings become more and more normal, perhaps that level of preparation will become less required. What I found surprising from the results on the screen here is that environmental sustainability is towards the bottom, and it may be because here in Scotland we've recently hosted COP26, but I suspect that consideration is going to start playing on more parties' minds, because certainly clients are going to become more and more aware and more and more concerned about their environmental responsibilities, and I suspect that clients will become under pressure from their stakeholders to ensure that there are no unnecessary international flights, and that hearings that can be conducted online rather than convening internationally are conducted online in order to save on the carbon footprint. So I suspect over time that particular result might start moving towards the left.
And perhaps this is the result of the fact that this was Australian practitioners responding, and without making you without wanting to flatter you too much, I think it's an issue of greater awareness in the UK than it is in Australia, although clearly momentum is building here.
Yeah, that may be the case, and with that momentum, it may be that if this survey is conducted, or a version of it further down the line, that we see that result is somewhat different.
If we could just quickly talk to the choice factor in terms of whether proceedings are to be conducted virtually, in person, or on a hybrid basis. We had quite mixed results, as the survey results show us here. Professor Sharkey, would you as arbitrator expect to nominate whether proceedings will be held virtually, or do parties generally come to you with firm expectations about how they believe the process should be, the process that should be adopted?
Well, I think now it'll be a rare arbitration where the parties haven't thought about the alternatives when they first meet with the arbitrator. Now, I wouldn't expect the parties to come to me with a final view on how IT is going to be used, but I do encourage them to begin thinking about that, and I'd like to see it as an agenda item, perhaps a recurring agenda item, so that the matter is constantly before the parties and the tribunal. And if there's agreement, which I would encourage, then well and good, but if there isn't, in the usual way, each of the parties can put their respective views concerning the matter, and a tribunal can give appropriate directions.
And I guess this is related to the next question as well, which then turns to, once the decision is made that proceedings should be virtual or hybrid, whose responsibility should it be to decide the manner in which that's then conducted. The parties won the vote in terms of, parties won the vote in our response, survey responses as to the participants to the proceedings who really should be responsible for and determine the hearing platform itself, the evidence presentation solution, the transcript solution. Does this accord with your experience and your preference?
That's directed to me, Kylie.
Yes, sorry, Professor Sharkey.
It's all right. If I can just go back, I think those matters affect, it's a question of when the decision is made that there's going to be a virtual hearing, and that may involve or could affect the nomination process, where a contemplated nominee is familiar with, or at the very least willing to learn how to use a preferred form of IT. That might be an appropriate inquiry to make before the nominee is confirmed. The parties might wish to tell the appointing authority about their anticipated needs and so forth. The likelihood is the parties are going to come to that first case management conference without having settled upon a particular form, and I think the arbitrator has an important role in the process. I'll want to know what options the parties considered, what proposals each has got in mind. While I'll say that while I know we all have to start somewhere, I'm probably internally hoping that I'm not going to be told that the IT provider is X and this is the first case of its kind that they've ever done. Ideally, I expect, and I'll express this view to the parties, that I can confidently rely upon the technical issues, internet connections, sufficient bandwidth, and that will all be dealt by an appropriate provider. But a consultative process between the parties and the tribunal of the kind to which I've referred gives the best chance of a cost and time-effective hearing consistent with what the parties will tell me as their rights to equal treatment and a full presentation of their cases. One thing I will insist upon is, if I'm not familiar with the particular form of IT that's been chosen, is training or instructions on how to use it, and I'll usually ask for a training or tutorial session in the presence of the parties' representatives a short time before any merits hearing.
Mm-hmm. Thank you. Did the panelists have anything else that they would like to raise before we just hand over to any questions that have come through from the audience?
Can I just mention one matter, Kylie, that occurred to me in reading the survey? Not listed in the disadvantages was time zones. And I say that in the comfort of Andrew and I sit on the east coast of Australia where it's approaching 1 o'clock. Here's Jamie in Edinburgh where it's approaching 3 a.m. in the morning. So this was an arbitration which we were both participating in. Jamie had commenced at 10 a.m. and Australian Eastern Standard Time. Jamie would be starting at 1 a.m. and concluding around 7 a.m. We might do that for a day or two, but after that, I think principles of equal treatment would seem to make a case for reversing, I should say, the roles, with Jamie having a conventional day and Andrew and I starting late at night and continuing into the next morning. And that can be both challenging to organise and manage, particularly if you've got more than just two continents involved and you've got people from North America and Asia and so forth. That's a recurring issue for the management of virtual hearings in international arbitration.
Jamie, what's been your experience where you are involved in arbitration spanning different time zones?
Thankfully, so far, I've certainly virtually not been involved in a evidential hearing that has required too much thought in that regard. Certainly hearings where participants have been elsewhere in Europe, but the time difference there is 1 or 2 hours and perfectly manageable. Someone starting their day slightly earlier and nowhere close to the kind of scenario that John's just set out there. But certainly something that has to be considered, and one would have to think, is a party disadvantaged by their legal team doing the night shift, as it were, and is their case going to be as well presented as it would be if working a conventional day?
And certainly if we're just talking about the participation of witnesses who may only be involved for a short period of time, it's not such a big consideration. But as you say, if we're talking about entire legal teams being located in a geographically remote location, then that's a different consideration.
The location of witnesses would also be a high consideration for me. I'm not sure how comfortable I would be with certainly an important witness being asked to give evidence at a very unconventional time for their time zone. Again, it's part of the preparation and thought that has to go into a hearing, and the earlier that kind of thing is thought about, perhaps the better.
So something that has been raised is really a suggestion, something that is a suggestion and a question for the panel that relates, I think, to the question of how best to educate arbitrators and counsel involved in ADR as to best practices and how that should be done. So one audience member has suggested that perhaps law societies could be involved in lobbying with government departments to set out online guidelines and standards to deal with management of witnesses and other procedural matters in a virtual sense. Would anybody like to speak to that suggestion?
Certainly in my jurisdiction, I suspect that's something that will happen in due course. Certainly our court system is now looking at where the future lies for virtual hearings, and the initial suggestion from our senior judge was that virtual hearings were going to remain a huge part of our justice system. That seems to have been rowed back a little bit. We are still essentially working on a temporary solution to a problem that started 2 years ago, and I think as the more permanent solution, as we move out of the pandemic, becomes apparent, then that is the sort of thing that certainly I would be expecting my representative bodies to be getting involved in.
Sorry, Carly, just on that question of I think that you know, as Jamie's identified, for court-based processes, definitely it gets a little bit more difficult with arbitral processes, and I think it's only a matter of time until protocols of general enough nature start reaching the familiarity levels of things like the IBA rules of evidence, where they can just be directly plugged in to people's procedural orders. I don't think we're there yet, and I've seen over the last couple of years a lot of very bespoke procedural orders in arbitration relating to virtual hearings, which run the entire range from there's going to be a virtual hearing and go and find yourself an agreed platform, to specifying how the witness is to be seated and the 360-degree spin around the room before the hearing. I just don't think that a standard's come yet, but it will, and it's all about the organisations getting together to have something that people can accept.
Yes, and like other elements of the electronic litigation life cycle, the e-discovery obviously has very clear established protocols that have developed over time, practice notes and accompanying protocols that deal with Court-based hearings are well established in many jurisdictions, so as you say, it's probably just an evolutionary issue, and it will come over time.
Yeah.
Is there anything else? I don't think we have anything else from our audience, so there's nothing else from the panelists. I might say again, thank you very much to Professor John Sharkey, Andrew Di Pasquale and Jamie Reiki, particularly Jamie, for giving us his time in the middle of the night. It's been great to have your insight discussing these findings. As I said at the outset, this webinar has been recorded and will be accessible after the event, especially for many of our international registrants who didn't have Jamie's dedication to participating live and being up in the middle of the night. So this will be shared. I've provided our contact details should there be any follow-up questions for any of the panelists. And certainly we will be jointly through Delium and the Institute be releasing survey findings and analysis as soon as that documentation has been completed. So thank you again for your time. I hope the topic has been as interesting to attendees as it has been to the panelists and to myself. Thank you and goodbye.
Thank you.